Welcome to the BLC box. My name is Will O'Dogwu. I'm a lecturer at the British Law Centre, and I'm very happy today to welcome our guest, Dr. Jonathan Morgan, Director of Studies at Corpus Christi College, Cambridge, and reader in English law. Now, Jonathan completed his undergraduate studies at Oxford, then went on to take his doctorate at Cambridge University. He's a very good friend of the British Law Centre, was actually previously a tutor at the British Law Centre, and continues to help us out every year by delivering guest lecturers for the British Law Centre's students. Jonathan's interests focus primarily on contract law, tort law, and general theory of private law. He's a very prolific author, so I encourage you to seek out the many contributions Jonathan's made over the years to book chapters and journal articles, etc. If you want a more extended treatment of some of Jonathan's ideas in the area of the sort of theoretical basis of English contract law, then please have a look at his book, Contract Law Minimalism, a Formalist Restatement of Commercial Contract Law. Today, we're going to talk about some presently topical issues. So as the very format we're engaged in is a eloquent demonstration of social distancing, with Jonathan situated over there in Cambridge and I'm speaking from Warsaw. What necessitates these kinds of arrangements? Well, of course, we're going through an extreme situation at the moment, at least in terms of government responses to the COVID-19 crisis. And so we thought we would have a look at from a more general perspective, but also in light of present events and also recently Brexit, how English contract law tends to respond to situations where there are major changes in circumstances. How does it manage the parties' obligations in such situations? So, hi, Jonathan. Thank you for joining us today.
Hello. Yes, let me just reiterate, I'm delighted to be here. It's slightly tinged with sadness that I can't actually visit Warsaw to give this talk, as I lived there, as you said, as a tutor for 2 years, 20 years ago now, and I visit a lot. So it's a shame not to be there in person, but I hope I'll be back in Poland soon enough when the crisis has passed. And as you say, there's never been a more topical time perhaps to talk about frustration of contracts, or force majeure, or vis majeure, or however people might usually refer to it in their legal systems. In preparing for this talk, I've had a look at the blog posts and articles and so on, and there's been a huge amount written about this already. So I think one thing that contract lawyers in the last few months, when they've been locked down, is that they think a lot about this subject. So yeah, it's a topical one.
Indeed. So so perhaps we'll just orientate things by starting from a very general level. So when do changed circumstances excuse the parties from the performance of their contract under English law?
Well, I think I'll start at a very general level and say that English law has a very narrow conception of frustration. Speaking very generally, the law is reluctant, the courts are reluctant to excuse a party from performance because circumstances have changed. The parties considering entering into a contract, especially a long-term one, would be very well advised to deal with the possibility of interruptions by putting a suitable clause in their contract. So in my view, the most significant way of dealing with this sort of situation would be by drafting the contract. So it's not at the stage of the pandemic breaking out. It should be thought about at the earlier stage of when the contract is initially drafted. And indeed, it's very common in contracts, and this is no doubt true around the world, but equally true of contracts governed by English law. They do very frequently have provisions such as a so-called force majeure clause, stating that in the event of certain sorts of interruptions, that various consequences follow, from giving an option to cancel the contract to delaying the time for performance, or various other possibilities. So the background legal position is there is a doctrine of frustration of contracts. It's very, very narrow. And because it's so narrow, parties would be well advised to deal with it in their contract.
Right.
That's the basic stuff.
A self-ordering response. So yeah, the best way through, parties to take responsibility for managing risks themselves of this nature. So perhaps we could turn into the background doctrine there, frustration, and drill down a little deeper. So in the circumstances where there is no force majeure clause, or perhaps there's a force majeure clause of inadequate scope, and please do tell me if we should differentiate between those two situations. What are the circumstances in which this frustration doctrine you've specified that it's of narrow range of circumstances would apply to? But I wonder if you could expand on that a little bit.
So if you were to read a textbook about this, it doesn't follow in quite the same way that I'm about to explain it. So textbooks would usually say there are various sorts of interruptions which might frustrate a contract. They would include performance becoming physically impossible. They would include performance becoming illegal. They would include situations where performance would be radically different from that which the parties had contemplated. And then you'll have examples of all these various things. Now, of course, I don't have time to go through it in great detail. But what I want to suggest today is that there are basically two subspecies of frustration, and they ought to be kept separate. And in particular, I think the situation of a contract becoming illegal to perform is actually in a wholly different category from any other sort of interruption. English law, so I've said that the doctrine of frustration is narrow and it is exceptional, and I stand by that point. But there's one situation in which we can predict very confidently that the contract will be frustrated, and that's the situation where it has become illegal to perform it. Any legal system, including English law, which has a narrow doctrine of frustration, any legal system has to have a doctrine saying that if the law changes the other legal doctrines, so to speak, if other parts of the law change to make the contract illegal to perform, then contract law, for reasons of consistency, the legal system as a whole, contract law has to follow that change in the law and say that the contract can no longer be performed. It seems very obvious, but just to make the point explicit, if we did not have the doctrine that supervening illegality frustrated the contract, then you'd be left with the extraordinary situation that a change in the criminal law, perhaps, which now made it a crime to do a certain thing. So we'd have the criminal law prohibiting the parties from doing something. And then the law of contract would say, however, you are still required to do this because you agreed to do it under the contract. And even though English law doesn't normally hold parties to their contracts literally, that's say it doesn't order them to perform, it would still be saying you must do this, and if you don't do it, you have to pay damages instead, which of course would tend to encourage people to perform. And if the performance has become illegal, contract law would be more or less ordering and certainly encouraging people to break the criminal law. So you can see how, just from the point of view of consistency between different branches of the legal system, the law of contract has to have a doctrine of supervening illegality. I mean, I think one way of thinking about it is, if we were to enter into a contract which is already illegal under the law, so a kind of black market contract, you can't have a contract for buying and selling prohibited goods like certain classes of drugs, and that would be an illegal contract from the start. It would not generate any binding legal obligations. For exactly the same reason, the law of contract has to be consistent with the criminal law there on prohibition of controlled drugs. So you've got to have consistency between different areas of the law. And it would be exactly the same, I'm not sure, when a certain kind of drug was first controlled. Let's say it was in the 1970s for some of them. And perhaps before then, you could have had contracts for buying and selling something like cannabis, perhaps. And when it became illegal to do that, the contracts would, at that point of the law changing, have been frustrated by change of law. So to me, the one part of frustration that you will find in the textbooks in the chapter on frustration should really be in a different chapter already, which is the chapter on illegality and illegal contracts. I mean, I'd say there are two kinds of illegal contracts. One's where it's illegal at the start, and there's never a contract at all. And the other kind of illegal contract is one where the parties have agreed to do something that's perfectly legal on the day that the contract is signed, but subsequently the law changes. And at that point of the law changing, it becomes an illegal contract and no longer imposes any obligations on either side. So if we look at the effects of frustration in English law, we say that frustration brings the contract to an end. Absolutely, it discharges all of the obligations on both sides, and it does this automatically. So there's no discretion in the court. If the contract's frustrated, it comes to an end automatically from the point of the frustrating event, and it terminates the contract on both sides. And again, all of that is perfectly understandable in the situation of contract performance having become illegal. There should be no discretion for the court there. The point at which the frustration happens is clearly the point at which the law changes. So it has to be automatic, and it has to have this drastic effect. Now, so far I've been talking about the situation of the law changing. I think all the other situations of frustration, which is where some other circumstances have changed, making it physically impossible or more expensive, more difficult to perform the contract, they fall under a different heading entirely.
And
shall I continue?
In those areas where we're not talking about the contract literally becoming illegal to perform, but something which has made it, I guess, a more difficult contract for the parties to perform in the way that, in the light of the new circumstances, we see the same sort of one-dimensional approach of the courts, that either the threshold is crossed at which the frustration doctrine applies, or it is not reached. But if it is reached, then there's absolutely no obligations between the parties, and if it's not reached, then everyone is held completely to their original contract in the new circumstances. Yes,
absolutely so. So let's move to look in a little more detail at those other situations of contracts becoming more difficult, more onerous to perform. Now, I think there is actually a debate to be had about whether you must have such a doctrine at all. I can't claim to know the law in every legal system in the world, obviously, but my knowledge of comparative law suggests that today every legal system does have some doctrine of this kind. A sufficiently radical change of circumstances discharges the parties from duties to perform. But actually, English law for many centuries didn't accept this doctrine at all. So there was a case during the English Civil War in 1647, where it was a contract of lease, and the land in question was occupied by enemy forces. So during wartime, the land was occupied during enemy forces, and the tenant said, I should no longer have to pay the rent. I'm not in occupation of the land. I've been displaced from the land by this enemy army, and therefore I shouldn't have to pay the rent. And the court said, no, we're sorry, you signed this contract, you agreed to pay the rent for this particular period of years. And if you wanted to have an excuse if something like this happened, you could have put an excuse in the contract. So it was this very, very strict approach saying, well, it hasn't become impossible for you to pay the rent is one thing to notice. It's true that you're not getting use of the land, but if you wanted to have an excuse in that kind of situation, you could have stipulated for one in the contract. So this was known as the absolute approach to contractual obligation, that there were no exceptions at all. If you fast forward 200 years to the middle end of the 19th century. The leading case of Taylor and Caldwell in 1863. This is seen as perhaps the leading case of frustration in English law. To summarize the facts rather drastically, this was about a hire of a music hall. The plaintiffs were going to perform a series of concerts in this music hall, and so they were concert promoters, producers, we might say, selling tickets to the public to come to these concerts. Then shortly before the concerts were to take place, the concert hall burnt to the ground. And they sued the defendants, who were the owners of the hall, for breach of contract, basically for the wasted expenditure. They'd spent a lot of money on promoting these concerts, sold tickets in advance, probably employed people to come and perform. So they sued for breach of contract, saying, we've wasted all this expenditure. We can't now recoup it because the concerts won't take place. Defendant is the owner of the music hall and argued, what can we do about this? The hall has burnt to the ground. It's true, in one sense, we're in breach of contract by not providing the plaintiffs with the venue to hold the concerts, but that's because of this superior force, the fire that has burnt the hall down. And the court agreed with the defendant and said, yes, the event of the hall having burnt down made it impossible for the defendant to perform their obligation, and that impossibility was rationalized as there being a term of the contract which said that if the hall should cease to exist, then the defendant is excused from performing. So it was rationalized as there being an implied excuse in the contract, an implied term. So that's Taylor and Caldwell in 1863. And from then on, the courts have accepted more or less that in extreme situations, there may be a defense of frustration based on impossibility or impracticability. But they, nevertheless, I think it's important to stress that throughout this time, 150 years now of this defense, they have kept it very, very narrow. The leading case in the 20th century is one called Davis Contractors in 1956. And the test that emerges there for the frustration of the contract is that the event must have made the contract radically different. The very obligations that the parties have must have been rendered radically different by the change of circumstances. Now, that's hard to define in the abstract, but certainly in concrete cases, what we find is that it is not radically different just because it's much more expensive to perform the contract. So Davis Contractors in 1956 was a building contract that had been signed just after the end of the Second World War in the UK. And at that time, in the 1940s and early 1950s, there were huge shortages of building materials and of labour, of workmen to do building work. And the result of all these shortages were that it became much, much more expensive to perform the contract. So the builders have agreed to do the contract for a certain sum, and they found basically they cannot perform for that money. It is unprofitable to perform. But the House of Lords said the contract was not frustrated by this change in the cost of performance, just because something became more expensive to perform had not changed its fundamental nature. So it had become a very bad bargain for the builders. They were no longer going to make a profit if they could perform at all. But that of itself was not enough to frustrate the contract. And perhaps I'll just give one more example of a recent case in the last 20 years, a case called the Mary Noor, which is the name of the ship in question. And this was a contract for supply of bulk commodities, specifically of cement. And the seller had obligations to provide millions of tons of cement to the buyer. So it was kind of world-scale cement shipping contract. It became impossible for the supplier to supply cement at all. I repeat, impossible. There was no cement. They could not buy cement to do this because a cartel had cornered the market in cement and then was refusing to sell it to the defendant, the seller, under this contract. So it was actually impossible. There was no cement to be had. It hadn't just become more expensive, it had become unavailable. But the court still said, sorry, you're in breach of contract, you haven't done what you said, you haven't supplied what you said you would, And if you make an absolute promise to supply these goods, you can't turn around later on and say, we did our best. It is an absolute obligation to supply. And the court said, although its decision seemed harsh, there were various things the supplier could have done. They could have put excuses in the contract. That's like the English Civil War case from the middle of the 17th century. They could have made their obligation dependent on continued availability of cement on the market. Or another thing they could have done is the defendants could themselves had entered into binding contracts with suppliers. So before they committed themselves to the claimant, in this case, to supply all this cement, they could have made sure they had absolute guarantee of supply under supply contracts of their own. So the doctrine today, it's still very, very narrow. Outside, as I've said, the situation of a contract becoming illegal to perform, where the courts, I wouldn't say they were generous about doing this, and perhaps the situations in which the law make changes to make it illegal to perform contracts. This is actually a very unusual situation. So it's not that those are common either, but I think if that happens, then the court will be much more likely to find the contract has been frustrated.
Well, I'm sure many of our viewers watching would be fascinated to see the example of 17th century English case law being used, even though if it has to some extent been superseded today. So we've seen a slight relaxation in the law, as you've described, especially with the landmark case of Taylor and Caldwell. And the cement supply contract you described just made me wonder, do the English courts show much sign of differing in the way they apply this frustration threshold, depending on maybe the sophistication of the parties involved, or how likely they are to be well advised, or the time for consideration that might go into concluding a contract, given the nature of the contract and the circumstances in which it's concluded?
That is a very good point, and in my view, which is somewhat tentative, that certainly should be something the courts would take into account. The reason why I say it tentatively is because, frankly, nearly every case that you will find in the law reports in England involves big, sophisticated commercial parties. A lot of the cases are about shipping. If you're a ship owner, you're a company worth tens, if not hundreds of millions of pounds, and the companies hiring the ships are usually very big concerns as well. Let's take oil tankers. I mean, the parties to these sorts of contracts are both big players, they are wealthy, they have sophisticated legal advisors. And it's true in many of the cases as well. I mean, Davis Contractors and Taylor and Caldwell, you go back into history, you often have individual businessmen and they're litigating about this. I mean, today it tends to be big corporations only. So in a sense, the very strict approach, and I think it is a strict approach that the courts take, it could be one that's especially suitable for sophisticated commercial parties and big businesses. If we had a lot of litigation involving consumers, small businesses, and so on, we might find in those cases, as your question has suggested, we might find in those cases the courts would be more willing to intervene. And I think there's a doctrinal reason why that might give them the power to do that. I mentioned very briefly that in Taylor and Caldwell, the court said that they were basing the excuse to perform on an implied term of the contract. Now, there's been a debate for at least a century about whether an implied term is the right way to think of frustration. I don't want to go into that now. It's a very theoretical question. Yet, in a recent case about implied terms called Marks and Spencer's and BNP Bank, the Supreme Court said that where you have large, sophisticated commercial parties, the courts will very rarely imply terms in, because if they want certain things to happen, then they should say so in the contract. So where you've got sophisticated parties with a detailed contract, the scope for the court to add further terms into it is very limited indeed. But I think the converse of that is to say, if you don't have sophisticated parties, if you have small businesses, consumers, perhaps they don't have a written contract at all, or it's a very, very brief contract, there is actually much more room for the courts to imply terms in. So you mentioned earlier a book I wrote some years ago called Contract Law Minimalism. I mean, that was a thesis saying courts should not intervene except in very unusual situations in commercial contracts. But I limited my thesis to sophisticated parties to commercial contracts, and said if you have less sophisticated parties, there is actually much more scope for the courts to intervene. So I think it's a very important point. What seems to emerge from the cases is the courts don't rescue the party who now can't perform, or sometimes doesn't want the performance, and we'll come on to a case like that later. They refuse to rescue them, and they say, we don't in the end feel that sorry for you, because if you wanted to have an excuse in this situation, you could have drafted the contract to excuse you. I've mentioned that the introduction, I think, the so-called force majeure clauses, which will say things like, in the event of natural disasters or government restrictions, the parties no longer have to perform, or the parties should renegotiate the contract. So clauses dealing very specifically with interruptions. But there are all sorts of terms in contracts that give flexibility in the face of what everyone knows is an uncertain future. So when you have a long-term contract, perhaps indeed an indefinite contract, a contract that's just going to carry on indefinitely, well, if you enter a contract like that, you can certainly foresee that life is likely to change. 10 years ago, who could have foreseen Brexit, or who could have foreseen a global pandemic on the scale that we're now seeing? And nobody could have foreseen these events. But if you pose the question differently and say, could people have foreseen that there might be some drastic political upheaval or some global pandemic, not necessarily a coronavirus, but it could have been SARS, or it could have been swine flu, or HIV, if one thinks of a slightly earlier global pandemic. So a global pandemic, a political upheaval would, I think, have been foreseeable within the next 10 years, because human history is littered with these, these sad events, which, from the point of view of the contract law, are sad events which have effects on contract obligation. Anyway, so I think, the harsh though it seems, for the English courts to say, we're not going to rescue you because you could have dealt with this, people will object and say, but we're dealing with unexpected events. How can parties deal with unexpected events? But if you read commercial contracts, you find that they are full of clauses that do this. So an indefinite contract will almost certainly have a termination clause, saying that parties can terminate on giving a certain amount of notice. Sometimes they have to pay, if they have an option to terminate, they have to pay a certain fee to the other side in order to terminate the contract. And of itself, the very fact that you have the power to bring a contract to an end by agreement is, of course, one way of making it flexible against the future. A particular area of law where this is of vital importance is with leases, but we'll come back to a case on that later, so I don't want to say more on it now.
Indeed. I mean, you've raised the events that will be on people's minds, I'm sure, watching this, which, of course, a little earlier, Brexit has now come to pass, even though we may not yet be witness to the full consequences of that event. And of course, what we're living through right now, which is the COVID pandemic. So maybe turning first to Brexit, have the English courts been called upon to resolve disputes that are based on a wish to avoid the enforcement of a contract, for example, on the basis of the political upheaval that is and was Brexit?
There has certainly been one case which we'd call a leading case. It's attracted a huge amount of attention. There's a very detailed judgment, a very learned judgment, going through the whole doctrine of frustration and its basis and the theory behind it. So it's a case that would be on anyone's reading list if they wanted to learn about the English law of frustration. And this did arise out of Brexit. So the name of the case is European Medicines Agency and Canary Wharf Limited, or EMA and Canary Wharf. So European Medicines Agency, as the name suggests, many people will know, This is one of the organs of the European Union with a certain regulatory function in the field of medicines regulation. Up until Brexit, it had had its seat in London, and indeed it had rented a large office building in Canary Wharf in London. I'll just refer to my notes here. There was a 25-year lease which was entered into in 2014. So actually not that long before the Brexit referendum, which happened in 2016 and perhaps became a political reality after the election of 2015. So not that long before the sort of immediate run-up to Brexit, there's a lease for 25 years on an office building in London entered by the European Medicines Agency. Now, after the vote in the UK referendum for the UK to leave the European Union, and once that had been confirmed with the UK government triggering the Article 50 process, the European Union decided, for very obvious and understandable reasons, to relocate the European Medicines Agency from London to Amsterdam. And the question then arose as to what effect this had on the lease that the EMA had signed for 25 years in 2014. And the EMA sought to argue that the lease had been frustrated, that Brexit had frustrated the lease. It was no longer obliged to pay the rent on the office building. Whereas the landlords, Canary Wharf, were saying, on the contrary, you signed this lease for 25 years and you remain liable ultimately to pay the rent on that building, even though you've now decided or been required to move out of it because you no longer want to have a seat in London, but in a city that is still going to be part of the EU territories. So this went to the High Court in London, and in a, as I've said, a very long and sophisticated judgment, Mr. Justice Marcus Smith held the contract had not been frustrated and the EMA still had to pay the rent. Now, it's not possible for me in a few minutes to do justice to all of his reasoning, but I suppose there were two strands to the frustration argument, and this maps onto how I described the doctrine earlier on. So the first strand was to say it had become illegal to perform. So the EMA said that because they were being required by the European Union to relocate to a city which remained part of the EU territories, that this was a legal requirement, and therefore it was illegal for them to occupy an office block in London. And so this is a fairly complex part of the claim, and to summarize, perhaps oversimplify, the judge said, well, just because you have to relocate, it doesn't make it illegal for you to pay rent on this office block. It certainly hadn't been illegal to sign the lease in the first place, and the lease contemplated, and I'll explain this more in a minute, the lease contemplated that if the EMA for any reason wanted to move its base of operations to a different office block, perhaps somewhere else in London, somewhere else in the UK, or indeed anywhere in the world, that even if it decided to leave the premises, it would still ultimately be liable to pay the rent. A subsidiary point that the judge made was to say, well, if the European Union, the government of the EU, of which the EMA is part, decides to change the basis of operations, it can't give itself the excuse to pay the rent under a contract it had previously entered into. So there's a doctrine of so-called self-induced frustration. Very commonly you see this in force majeure clauses as well. It would say, well, if there is a natural disaster or if there is some government regulation which makes it impossible to perform the contract without the fault of either party, then the performance no longer has to be rendered. So it's very, very common both in common law frustration and in force majeure clauses to find that it doesn't have to be, or it has not to be, the conduct of either party that's at fault here. Now, that argument is slightly controversial because you might say, well, the European Medicines Agency didn't have any choice. It's being ordered by a kind of superior decision-making body within the EU to do this. And whether it's right to equate the European Union government with a particular agency, the EMA, is, I think, controversial. Anyway, the judge in the end dismissed this and said it hadn't become illegal for them to pay rent. The EMA still had capacity to pay rent on the office block in London. It was true that this was financially damaging for the EMA because they would now have to pay rent on an office block in Amsterdam, which they were occupying, and an office block in London, which they were not occupying. But that simply resulted from their decision to change their seat. And you can't, obviously, normally, if you decide to move to a different building, and that can't of itself excuse you from paying rent if you've entered into a 25-year lease, which still has, I suppose, about 20 years to run when the judge gave his judgment. Okay, so it was not a contract that had been frustrated by illegality. The second argument that the EMA had was to say, well, the purpose of the lease has been frustrated. While it is true that we could physically still occupy this building, and while it is true that it's not impossible for us to pay the rent, the whole purpose for us to be in Canary Wharf has gone as a result of the Brexit vote by the British people and the European Union's relocation of the EMA. So they said that the purpose of the contract was intimately linked to the European Medicines Agency being based in London. And because that purpose had gone, that frustrating. And again, the judge dismissed that, I think, making two important points. First of them was that that might well have been the purpose of the EMA. You know, the EMA's purpose for renting this office block was because it was to be based in the UK, owing to political decisions by the European Union at the time a lease was signed. So that was certainly the EMA's purpose. But Canary Wharf's purpose was not that at all. I mean, Canary Wharf in the end didn't mind why the tenant was there, and they perhaps didn't mind who the tenant was. I mean, perhaps there are advantages and disadvantages to having a government agency as a tenant in a commercial office block. But in the end, Canary Wharf, all they wanted was someone to commit to signing this lease for 25 years. Canary Wharf then, I might say, adapted the office block, adapted the premises for EMA's purposes. So that's a reason why this was a long-term agreement, is that the landlord was arranging the premises to be suited for the EMA's needs. So the judge didn't think there was a shared purpose. He thought that clearly it was the purpose of the EMA, but Canary Wharf in the end were indifferent. And he backed this up, and perhaps this is the key in the end to the decision in this case, by looking carefully at the terms of the contract, so this lease contract. And I think if I make one general point for everyone here, is that these frustration cases do in the end turn on the precise nature of the agreement, the precise context, the precise terms of the contract. So it's actually quite hard to advise in the abstract about whether any given contract's been frustrated, for example, by Brexit, or as we'll come on to by the pandemic. So in the Canary Wharf case itself, the judge pointed out that this was a 25-year lease with no break clause, Now that's a technical term that landlord and tenant lawyers use in England, at least. And a break clause is where the tenant, or it might be the landlord, both of them, has the option to bring the lease to an end. Okay, so although the lease is said to be for 25 years, there might be a break clause every 5 years in which one or both parties have the option to bring the lease to an end. Or sometimes it might involve a renegotiation of the rent at fixed periods. But an unusual feature of, or at least a striking feature of the Canary Wharf lease in this case, was there was no break clause. The EMA had signed this lease for 25 years. and they had argued, they had tried to negotiate for a break clause, giving them the option to leave the premises and terminate the lease earlier than 25 years if that became something that they wanted to do. But Canary Wharf didn't want that. They wanted the rent for the whole period. So and in the end, the EMA, like Canary Wharf, were just very, very good at negotiating, and the EMA were very poor. But as the judge pointed out, the EMA definitely got something out of this, which was the rent that was charged was lower than it would have been had there been a break clause. So they did receive an inducement. Commercially speaking, they had an inducement signing up to this pretty long-term obligation without a power to terminate the lease, which was they got a lower rent charged by Canary Wharf, the landlord, than would otherwise have been the case. So what the judge was saying really was that never mind the precise contract terms, but the structure of the commercial bargain was that this was indeed a long-term commitment, and the EMA had no flexibility in wanting to, if at any point during the 25 years they wanted to give up the tenancy altogether, they did not have the option to do that. They asked for one, they tried to bargain for one, and in the end, the parties decided not to put it in. So stopping there, one could say, well, in the end, the EMA was trying to argue that the court, through the frustration doctrine, should give it for free what it had been unable to bargain for, or indeed to pay for, at the earlier stage of the negotiations. So the judge concluded it would be subverting, upsetting the structure of the bargain to hold that it was frustrated now. Because there's a passage of the judgment where he talks about whether Brexit was foreseeable, and he says, no, it was not. Certainly not in 2014 when the lease was formally executed, nor in 2011 where actually the agreement for the lease was, so you have an agreement and then formal execution of the lease slightly later, and the agreement had been as early as 2011. And either in 2011 or even 2014, Brexit was not a foreseeable thing. No one was putting Brexit clauses in their contracts then, and I'm sure they do now. So that was basically, it was saying the structure of the bargain was such that the EMA, had they had a break clause, now a break clause is not a Brexit clause. Nobody in 2011 would have said, okay, we should put a thing in a lease saying, if Britain leaves the European Union, then you can give up the lease, because nobody could possibly have foreseen that happening specifically in 2011. But the break clause they wanted wasn't saying, if Britain leaves the EU, you can end the tenancy, but just saying you can end the tenancy for any reason at all. For changes of circumstances that we cannot now foresee or define, any change of circumstance would have allowed you to terminate under the break clause. A final thing to say, because the judge makes much of this too, is that while it looks like an extremely hard outcome of what I've said so far, but actually there were certain provisions in the lease which made things less serious for them than might seem. Namely, that they had the power to sublet the premises or to assign the tenancy. So what that means is, and I don't know what has happened since the case was decided a year ago, perhaps this has now happened, that the agency has the power to assign the office premises to a different tenant. Okay, so if they can find a different tenant who is willing to take on the original lease for the remaining period, they can assign the tenancy to that. So they might find some business who wants to move to London or expand its operations, they want to take on bigger premises, they can assign this lease to them. And then, of course, once that happens, a different business takes over the premises, takes over the obligations to pay the rent, and then the EMA actually is excused from its obligations, not by the doctrine of frustration, but because it's used a provision in the contract. And Canary Wharf are quite happy because someone else is paying the rent. In the end, Canary Wharf don't mind paying the rent, but someone is doing it. So hence there's this provision allowing an assignment of the lease. Or the alternative would be for the EMA in effect to become a landlord itself. So the EMA is renting the premises from Canary Wharf, and then the EMA could sublet them by entering into a subtenancy with the company probably that then becomes their tenant.
Mm.
The subtenant pays the rent to the EMA, and then the EMA pays the rent that it owes to Canary Wharf. So in other words, there are a couple of ways commercially and using the provisions of the lease by which the EMA can, in effect, get somebody else to take over its obligation to pay the rent. But the sting in the tail there is, if they cannot find another company to take over this obligation, then they remain liable to pay the rent. So the backstop, we heard much about the backstop during Article 50, and the backstop of this particular lease was to say, in the end, the EMA has to pay the rent. But there are various ways that they can try and reorganize things. And whether they're successful, I wouldn't like to speculate. It will depend a lot about rental values of office buildings in London. Brexit, of course, itself has affected that, and now we've got the pandemic, where it's too early to say. But some people are forecasting a crash in the UK property market, and no doubt world property markets as well. So I don't want to suggest the EMA has an easy way out of its obligations. It might end up being a very expensive decision. Anyway, I've talked a lot about that. It's a very, very interesting case, not only topical and not only the perhaps slightly public law dimension of whether the European Union was in a sense responsible for its own plight by ordering the EMA to move its seat.
Indeed. No, I mean, it sounds a very interesting decision. Because of its complexity, I mean, there's a plethora, a wide range of sort of supporting elements, it sounds, to the outcome of the case, and but it does seem to reveal, as you mentioned, that the contract itself, the specific contract in question, is a crucial reference point, and seems to highlight the importance of the visibility of the trade-offs that are encompassed by the agreement that was struck. Maybe the wisdom of keeping contemporary records of how negotiations are progressing as well. But no, a very interesting case that I'm sure will attract much more discussion in the future. Hopefully, some of that perhaps coming from your direction. So I will move on to, as you mentioned, COVID is also another area where, obviously, at the moment we're really preoccupied with the effects that this is having on our lives. And it may be too early to say, but is there anything that we can say about how parties are responding to COVID in terms of their contracts, what the courts might be doing if arguments are being made to release parties from obligations, whether there's been legislative involvement that affects the picture? So any light you can throw on that? I know it's a fast-moving issue and it's early days yet.
Well, there certainly hasn't been any litigation about it yet, and I wouldn't expect there to be any for a few years. But I'm sure it's definitely in the pipeline, and I think the courts will have to test the position out. Force majeure clauses, as I said, they are common in commercial contracts. They're by no means universal. I don't want to say every contract has one, necessarily has to have one. But if you do find a force majeure clause, they will not uncommonly refer to quarantine, pandemic, public health emergency, and so on. I don't think any contract drafted more than 6 months ago would specifically have referred to COVID-19. I mean, how could they? Because it is a new disease. And you really would have had to have the foresight of a prophet, as Lord Denning once put it, to have foreseen this particular thing happening. But I don't think it was, I've said this already, I don't think it was unforeseeable that some public health emergency or pandemic, globally circulating new infection could have all this disrupting effect on our lives and on trade and on contracts, because it has happened before. Some people, I think, would say that it's not for a century that we've had a pandemic as serious as this, that the Spanish flu in 1919, so-called Spanish flu, some people say actually arose somewhere in America. It was at the end of the First World War, 1919. It's probably the last pandemic perhaps on this scale. But other public health emergencies have happened since then, and contract drafting shows that. And because force majeure clauses are they're individually drafted. It's not that there is one so-called boilerplate provision that every contract contains. The wording is somewhat different. Some, as I've said, some might talk about a pandemic, some about public health emergency. Another kind of a phrase that you find in these clauses, which may be fruitful here, is about government restrictions, or you might say that there are two elements to the disruption of trade that contract lawyers are seeing. And one is the sheer economic effects of a serious global recession, which we're just starting to see now. But of course, the other thing here, which is different from, say, the world financial crash of 2008, is that a lot of the immediate economic harm is being brought about by government regulations. I mean, certainly, as I speak today, somebody who owns a pub or a restaurant in Cambridge, they legally cannot open these businesses. Perhaps they can readapt as some sort of takeaway facility, but they certainly can't have any customers inside their premises, and that's a legal requirement, a legal restriction under the emergency legislation that British government and Parliament have brought in. Anyways, so I think there is bound to be a down the line about what exactly these force majeure clauses mean. Do they cover this situation or not? And it's hard for me to say in the abstract whether they do, but clearly contracts will be drafted, perhaps with hindsight, with greater or lesser specificity or greater or lesser obvious application to this situation. I'll cite one piece of research. I've mentioned a lot of people have been writing about this. One piece of research I saw, which was a slightly separate question of material adverse changes clauses in mergers and acquisitions. So if I agree to buy your company for several $1 billion and we sign on the dotted line, and the actual completion of the sale, I suppose the transfer of the shares into my name, is to take place some months down the line, very often those agreements will have a material adverse changes clause. That's to say, if there are material adverse changes, then I no longer have to go through with the sale, or perhaps it will have an effect on the price of the sale, something like that. Now, what authors of this study found is that after the various global health concerns, scares of the last 20 years, I've mentioned already, MERS, SARS, swine flu, after each of those, the number of contracts containing pandemic clauses has jumped. So I think there is a sense in which contract drafters do use a little hindsight. That's to say, once a certain kind of event has happened, then people are more likely to put specific clauses in their contracts. Brexit is another example. Who would have put a Brexit clause in a contract in 2011 or 2014? But I think I assume it's now very, very common indeed for any commercial contract which might be affected by the terms of the withdrawal agreement, or the ongoing trading treaty between the EU and the UK. I'm sure that sophisticated contractors are now putting a Brexit specific clause in their contracts to try and deal with that. So there's a sense of shutting the door after the horse has bolted, but I don't think it is only that. Even those drafting contracts are human. Once there's been a particular interruption, people then put specific clauses in to deal with it. The final example is to do with the Suez Canal. When the Suez Canal was nationalized by the Egyptian government and closed for a time in the 1950s, this had huge disruption to international trade because of so many shipping routes passing down the Suez Canal. And there was a lot of litigation in England, in America, and lots of other countries about the effect that had on shipping contracts. But one lasting effect is you now commonly see a clause about closure of the Suez Canal and the Panama Canal, sort of similar strategic importance, in case this ever happens again. Okay, so that's one thing that we'll find. There's bound to be litigation about force majeure clauses and whether they apply to the COVID-19 situation, both the public health side of it and the government restrictions side of it. Secondly, there is the question of illegality. Have contracts become illegal to perform? And I think there's actually fairly narrow scope to argue this. I mean, I think it will be argued, and some contracts will fall within it. A situation in which a lot of contracts were frustrated by becoming illegal to perform is wartime, especially the sort of serious sort of existential war that we saw in the UK between 1939 and 1945. Because a number of things happen. First, it is a crime to trade with the enemy. So if a German company and a British company had signed a contract for sale of, bits of wood or whatever in 1938, as soon as war was declared between Britain and Germany in September 1939, it would become crime to perform that contract, right? Trading with the enemy. And then later on, there were more specific regulations on the economy, the war economy in Britain. And to think of these illustrations sound very random, but they're taken from leading cases. Timber businesses, so trading in timber, this became illegal, private trading in timber, because it was all commandeered by the government. And also distribution of cinema film was also highly regulated by the government, right? Because these raw materials, timber, celluloid, and so on, they were needed for the war effort. So there are all sorts of contracts, either because of the identity of the parties, British and German, or perhaps British and Italian companies, when those countries were at war, became illegal to perform, or certain areas of trade where, in effect, the government took over the economy altogether, and private trading in that was made illegal as a consequence. But if we look at COVID, most of the restrictions are really stopping businesses from doing business with the general public, because the point of the public health emergency is to keep people in their homes, not to get them to go out to the pub or to a restaurant or to shops, except food shopping. So it's true that if I own a clothes shop, I am now prohibited by law from admitting customers into my shop to come and look at the clothes and buy them. But that's not putting me in breach of contract with any of the customers, because I don't have an ongoing contractual obligation to sell them anything. I mean, usually I'm open, they can come and buy the clothes, but I don't think there are going to be breaches of contract between the businesses, shops, pubs, restaurants, and their customers. So the thing that's been made illegal is not usually subject to an ongoing contractual relationship, an ongoing contractual obligation. And so that's why, to me, these cases that you see an awful lot of during the Second World War, they don't easily map onto the kinds of legal restrictions that we've now got in the UK economy. Of course, the economic dislocation from this pandemic is to be seen, but the British Chancellor of the Exchequer has said we're going to have a recession like one we've never seen before. So some people have said it's going to go, records so far suggest it will be the worst recession since the Bank of England was founded at the end of the 17th century. So it's going to be, the economic harm from this is going to be catastrophic. So one might think that this would affect contractual obligations. Well, how can I pay my rent if I'm renting a shop unit and I'm not allowed to open my shop and I haven't got any customers? Or even just more generally, how are people going to pay rents on their houses if they lose their jobs? But as we've seen already, the frustration doctrine usually says that mere economic changes, making it harder to perform, more expensive to perform, or a party with financial obligations has less money coming in. I know of no examples of contracts being frustrated under those situations. In fact, I think it's very likely that they will not be frustrated by that. So I did wonder whether there was a case for, and you mentioned it in your question, a case for legislation here. Because again, to go back to the Second World War, there was a statute enacted by Parliament called the Liabilities Wartime Adjustment Act of 1941. So back in 1941, when the war was raging, the British Parliament was worried about the effect that wartime interruptions were having on all sorts of businesses, especially small businesses, and how to basically avoid people being bankrupted by the wartime situation. So far, this is very similar to COVID. I think. And the legislation I've mentioned, the 1941 Act, it did a number of things, but most pertinently, it gave the court the power to reduce rent in leases and to vary the terms of other kinds of contracts. If by doing that, it could help businesses to carry on trading. In other words, could avoid them being bankrupt situation.
Indeed. Yeah.
And the reason why that considered, and maybe it has been considered, here dealing with one-off situation burning down in Taylor and Caldwell. I mean, it's a disaster, but only for a kind of relatively small group of people. Or for the cement cartel in the Mary Nor. Now, no doubt for world cement dealers, this was a kind of, great drama, but for the rest of us, we've not even heard about it and not really been affected by it. But when you have something like a national war, or now the COVID global pandemic, this is not just affecting a few people, this is a catastrophe that's affecting everyone. And so I wonder whether there's a case just from the regulatory perspective, instead of leaving it to the courts to sort of stumble through on a case-by-case basis, whether there might be a case for having legislation, general public legislation, saying all contracts are affected by this, and courts should be empowered to adjust for contractual obligations. Because one thing I perhaps have not made sufficiently clear is, if you argue a contract's frustrated in English law, and if you succeed in arguing that, the contract automatically comes to an end. And that's it. End of. Now, if you're a shop unit in Cambridge, say, you're finding it hard to pay the rent because of the current economic situation, you might not even want to say that the lease is frustrated, and you might not want to, because then you won't have any shop at all. You won't have any premises to trade from when things return to normal. So you might not want to argue the lease is frustrated, or some people might want, might be commercially convenient or not to argue that. But if you had a power to adjust liabilities, let me just remind you, the title of that wartime legislation was the Liabilities Wartime Adjustment Act. So what if we were to have a Pandemic Adjustment Act 2021, which gave the courts this power? Because I do think in the end that COVID, as well as it being a public health emergency, it's also now a national economic emergency. And there is a case for legislation to empower the courts to adjust obligations. I don't want to suggest the 1941 Act, in a way, it's a historical curiosity. At the time it was enacted, an article was written in the Modern Law Review in 1941, where some contract law professors pretty much raised their eyebrows, and they said, this is so different from the common law approach to frustration that we wonder how much use the courts will make of this power to adjust obligations rather than end contracts altogether. And at least as far as court litigation and reported cases are concerned, it seems the act did not generate very much case law, and of course it was repealed after the war. So perhaps this was not a situation, even a solution even then, which, while theoretically interesting, perhaps didn't have much practical impact.
Yeah, I guess there are administrative limitations.
So far, yeah, well, there's all the expense of going to court. And I think realistically, what will happen in this situation is that I've talked about parties needing to think about interrupting events when they sit down and draft the initial contract. That's wonderful advice, but it's too late, isn't it? That COVID has now happened, people have signed the contracts. It's no good me saying you can go back in a time machine and alter the terms of the lease or the other contract. You can't do it. We are where we are, and the focus will now be on people renegotiating their contracts. Now, it would require it would double the length of this conversation if I was to talk about the issue of modification of contracts in English law. But I think that is now where the interesting action is going to be. Because take a landlord whose tenant is a shop and can't pay the rent. I mean, the landlord could insist and say, sorry, the lease is not frustrated, you still have to pay the full rent. Well, almost certainly the result of to drive the tenant into bankruptcy, and the landlord may get no money at all. So the commercially sensible thing might well be for the landlord to accept a reduction in rent during the initial legal restrictions of COVID and then the ensuing economic downturn that I'm convinced, and most people are convinced we're about to see. And then hoping that the rent will go back up to its original level in a few years' time when the recession maybe has run its course. And anyone who knows anything about English contract law, which of course might not be anyone listening to this talk, a case that's of great fame is the case of High Trees House, decided by Lord Denning when he was a junior High Court judge in the 1940s. And that was exactly this situation. It was a landlord accepting a lower rent on a block of flats in London during the war because a lot of the population of London had left and gone to the country to seek greater safety. And there were various technical doctrinal problems why these had not been modified in a binding legal way. And so the landlord was now saying, no, sorry, we want to claim the full rent, even though we said we'd accept a low rent. They said, no, we now want the full rent. And Lord Denning said, well, once the war had ended, you could do that if you gave adequate notice. So in a sense, the landlord won. But then he looked back and said, but what if the landlord had tried to claim the full rent for the years during the Second World War when they'd said they'd accept the lower rent? And Lord Denning said, actually, the landlord would not be able to do that. Now, this judgment is very famous. It's the basis of the modern doctrine of promissory estoppel. And I think it shows a number of things as perhaps a good place to conclude more or less. First is that where we have these great disruptions, war, and now a pandemic, parties commercially will need to renegotiate their deals. And that's what had happened in the High Trees case. And secondly, the courts English contract law ought to facilitate that and should uphold commercially sensible modifications. So rather than just holding contracts are frustrated and ended altogether, I think both the commercially and legally appropriate way of dealing with the situation is for people to sit down, renegotiate their contracts, and for the courts to accept that the modifications have been made in binding form. So this could get us, as I say, to part two of this would be a discussion of modification, consideration, promissory estoppel, and frustration is kind of background issue in those cases, in fact. So there we go. So my prediction is, yes, there'll be plenty of litigation about this, and some of it will be about frustration in the narrow sense, but perhaps more of it will be about the interpretation of force majeure clauses, and will also be about agreed modifications to obligations.
Well, indeed. I mean, those who are watching who may end up joining the British Law Centre to study with us will obviously see that English law does present some hurdles on occasion when it comes to modifying contracts, and that there are obviously straightforward techniques that a well-advised party can use to avoid those hurdles. But indeed, as you point out, English courts that facilitate adjustment of contracts by the parties themselves in the course of crises such as these, those approaches that facilitate renegotiation are perhaps going to be very important. So, I mean, I think this concludes, pretty much what we wanted to discuss today. And on a final note, I just wanted to perhaps ask you, I mean, how have you been affected by COVID? How is your household affected? How has your professional life been impacted?
Well, I've actually been on sabbatical leave this year, so my own teaching has not been affected. It's just that I don't have any teaching obligations. I'm about to do a lot of marking because Cambridge students are still sitting examinations. They're not in Cambridge, and they're not going to be handwriting them. They'll be sitting them remotely and type their answers, but more or less with certain modifications that they'll be sitting a fairly similar sort of assessment. But I have young children. Sorry,
I was just going to say, is that going to be a relief not to be dealing with handwritten submissions, perhaps?
Yeah, well, I mean, it's a change I've been in favour of for many years. Actually, is that students should be given the option of typing rather than handwriting their scripts, because apart from this purpose, I think very few people handwrite anything other than birthday cards these days. So I hope that might be one positive sort of lasting change of the crisis, as we can stick with students typing their answers. But more generally, we're now looking ahead to next year, and it's very difficult to know what the legal restrictions will be applying to universities from next year, and I'm sure that's true in Poland and other countries. And on a personal note, I'm very young rather than university. Exactly 3 months, so that's very nice in some way. It's made work.
Indeed. Well, I think we'll just conclude it there then, and I'd say thank you very much on behalf of the British Law Centre and all of those viewers out there who will be gaining a lot from our discussion today, I hope, and from the insights that you're able to bring to this area of current concern. And of course, we at the British Law Centre are looking forward to when you can join us again at the British Law Centre centres around Central and Eastern Europe. But, you know, we are in those situations that we've been discussing. And so if it comes to pass, then of course, we will invite you to participate online with our students, and we'd be really grateful to welcome you back.
Yes, well, as you say, I'm hopeful that I can join you and the students in person at some point. But we have to adapt to the situation that there is, and if it's a virtual appearance, then that will be almost as good. Although I will certainly miss my annual visit to Warsaw if I can't do that.
Oh well, let's hope we're moving into sort of a sunnier period now, and the signs are good, perhaps tentatively. So thanks once again very much, Dr. Jonathan Morgan, for talking with us today, and I wish you all the best and look forward to seeing you again in person in the near future, hopefully.
Thank you.
Thanks, Jonathan.